The Supreme Court chamber was steeped in silence, heavy with the weight of constitutional consequence. Rows of spectators leaned forward, breath held, as Justice Amy Coney Barrett adjusted her posture. The moment had arrived. Pamela Bondi, the former Florida Attorney General, stood at the podium in her tailored navy suit, fingers wrapped lightly around the wooden edge. Representing a coalition of 17 states in a landmark federalism case, she had barely begun her oral arguments when the first strike came. "Miss Bondi," Justice Barrett's voice rang out, precise and measured, slicing through the air like a scalpel. "Your constitutional interpretation directly contradicts precedent in no fewer than 3 Supreme Court rulings. I strongly suggest you revisit Harrington versus Davis before presenting arguments of this nature." A ripple of quiet murmurs passed through the chamber. Even some of the other justices glanced sideways at one another. Justice Barrett, known for her composed demeanor, had just fired a shot across Bondi's bow. The implication was unmistakable. Bondi was out of her depth. Bondi's lips parted slightly, caught mid-thought, but she did not flinch. Her fingers brushed across her notes with deliberate calm. "Thank you for that, Justice Barrett," she began steadily. "I'm quite familiar with Harrington, and if I may, I believe it supports our position more than it contradicts it." Barrett's brow furrowed, a flash of skepticism evident. "Proceed." Bondi inhaled smoothly and began. Harrington centered on a restrictive view of the Commerce Clause, with Chief Justice Reynolds emphasizing that federal authority must clearly outweigh state sovereignty in such matters. The majority emphasized this limitation, and Justice Kavanaugh's concurrence introduced a vital 3-part test. Without looking down, she recited from memory. Federal action must be narrowly tailored, reduce administrative burdens on states, and serve a compelling national interest. Barrett leaned forward slightly, her expression sharpening. The argument was sharper than expected. Bondi continued, "When applied to the present facts, the federal regulations in this case failed 2 of those 3 tests. In contrast, the Harrington regulations passed all 3. She paused briefly before moving on. "Furthermore, in Westmoreland v. United States, the 10th Circuit struck down federal rules that didn't satisfy the same 3-part test, despite federal interest being present." Justice Sotomayor interjected. "Counsel, Westmoreland is not binding precedent. It's a minor appellate ruling." Bondi nodded. "That's correct, Justice Sotomayor. But in Montgomery v. Louisiana, this court cited Westmoreland's reasoning in footnote 23, particularly when discussing federal boundaries in traditional state matters." Justice Barrett's expression shifted, just slightly, eyes narrowing with reconsideration. Pam Bondi pressed forward. "Now, regarding Article 3 jurisdiction and the question of standing," Barrett cut in again, still testing. "Your interpretation contradicts your own writings, Miss Bondi. How do you reconcile that?" What followed stunned even Barrett. "Justice Barrett," Bondi said, her tone confident, almost conversational. "If I may refer to Justice Scalia's dissent in Williamson County, which was later vindicated in Nick v. Township of Scott, we find a broader approach to jurisdictional limits. That decision overruled the main holding of Williamson and reshaped how we view standing." Barrett raised an eyebrow. "Are you suggesting Nick applies to federalism here?" Bondi didn't flinch. "Yes, Justice Barrett, but not directly. Rather, it illustrates how lower court interpretations expanded Nick's logic beyond property rights, touching on fundamental state discretion." The chamber shifted again, this time in Bondi's favor. Justice Clarence Thomas, who had remained impassive until now, leaned toward his microphone. "Miss Bondi," he said in his resonant baritone, "you reference Nick's doctrinal ripple effect. Do you assert that such a precedent alters the threshold for federal encroachment upon state regulatory domains?" Pam Bondi turned slightly toward him. "Yes, Justice Thomas. not in a wholesale manner, but in spirit. Nick affirmed that when federal authority obstructs core state functions without a clear constitutional mandate, judicial restraint becomes not just appropriate, but necessary. There was a beat of silence as her words sank in. A subtle murmur rippled across the audience gallery. Some clerks took rapid notes. On the bench, Justice Elena Kagan watched Bondi closely, lips pursed, index finger tapping lightly on her bench. Justice Kagan then broke in. "Miss Bondi, let's put aside the Commerce Clause for a moment. What do you say to the Solicitor General's assertion that your argument, if adopted, would render vast swaths of federal regulatory infrastructure unconstitutional overnight?" Bondi didn't blink. "Respectfully, Justice Kagan, that concern presumes a binary relationship between state and federal power. But the framers envisioned dynamic tension, not subordination. Our argument seeks not to dismantle regulation, but to restore balance. We are not here to destroy the bridge. We are here to inspect its load-bearing limits." A few audible gasps from the back row. Justice Neil Gorsuch leaned in next, visibly intrigued. "Would you go so far as to say that this case invites a revival of the anti-commandeering doctrine?" Bondi allowed herself a half-smile. "Not a revival, Justice Gorsuch. A reaffirmation. The doctrine never died. It merely slept beneath the noise of expanding federal reach." Justice Barrett's gaze hadn't left her. The scrutiny was relentless. "But your briefs cite Printz and New York versus United States almost as gospel. Wouldn't your interpretation reduce cooperative federalism to voluntary participation, stripping Congress of its coordinating role?" Bondi met her eyes directly. "Justice Barrett, voluntary participation is not weakness, it is sovereignty, and Congress still holds the purse. Nothing in our argument prevents incentives, only coercion." There it was again, that narrowing of Barrett's eyes. Reassessment, not agreement, but something adjacent. Then came the moment that changed the temperature of the room entirely. Justice Ketanji Brown Jackson, who had thus far observed with judicial reserve, spoke up. "Miss Bondi, let me ask a more philosophical question. Is your coalition's endgame a restructured federalism? Or is this merely a litigation tactic to push back against unfavorable federal oversight?" Bondi took a second. Her voice softened, but not her resolve. "Justice Jackson, we represent citizens and legislatures that feel smothered, not by the law, but by the machinery behind it. This isn't about resistance. It's about responsibility. If we've reached a point where questioning the boundaries of federal power is seen as tactical rather than constitutional, then perhaps we've already lost sight of the contract we swore to uphold." That was it. Even Justice Roberts, usually stoic, lifted his chin a fraction. In the spectator gallery, the buzz was tangible. Pundits whispered. Court sketch artists rushed their pencils. Legal aides exchanged glances, some in disbelief. Pamela Bondi wasn't retreating. She was maneuvering, smartly, surgically, and with increasing command. Justice Barrett didn't say another word for several minutes. When she did, it was barely above a murmur. "You may proceed, Miss Bondi." Bondi straightened her papers as if nothing had happened. But something had, and the entire room knew it. By the time the clock struck the midpoint of the session, the atmosphere inside the Supreme Court chamber had transformed from icy skepticism to a simmering intellectual standoff. Justice Samuel Alito adjusted his glasses, eyes fixed on Bondi. "Miss Bondi," he began, his tone cautious but curious, "if we entertain your reading of Harrington and its three-part test, would that not require us to effectively overturn significant portions of Gonzalez versus Raich?" Bondi nodded slightly, as if anticipating the blow. "Not overturn, Justice Alito, refine. Raich was context-bound, focused on intrastate activity that substantially affected interstate commerce. The case at bar involves a wholly different species of state action, regulatory, not economic. We argue for doctrinal precision, not revisionism. A brief hush followed. Then Justice Kagan struck again, sharper this time. Counsel, let's not play semantics. Your argument would open the door for states to challenge every environmental, healthcare, or education-related mandate they find inconvenient. That's chaos. Bondi leaned in. With respect, Justice Kagan, what you call chaos, the 10th Amendment calls accountability. The room froze. That line, delivered without flourish, landed like a thunderclap. Even Chief Justice Roberts looked up from his notes, but it was Justice Barrett who leaned forward once more, elbows resting on the bench, fingers steepled. "Miss Bondi," she said, now calm but intense, "I want clarity. Are you asking this court to set a new constitutional test for federal overreach? One that would, in practice, limit congressional power far more than existing precedent allows?" Bondi didn't hesitate. "Yes, Justice Barrett, but not a new test. An explicit recognition of one that has quietly guided this court for decades. What we're seeking is doctrinal honesty." Justice Barrett cocked her head. "Then explain to me. If we grant the relief you seek, what stops future litigants from invoking this framework to dismantle decades of civil rights enforcement?" The air thickened. It was a loaded question, one designed to corner. Bondi took a measured breath, her voice unwavering. "Because, Your Honor, there is a difference between federal enforcement of constitutional rights and federal imposition of administrative preferences. One is protected by the 14th Amendment. The other is tethered to an ever-expanding interpretation of the Commerce Clause. This case is about the latter, not the former." Barrett's eyes searched hers. No flicker, no retreat. Only the methodical rhythm of someone who had spent years preparing for this very moment. Justice Jackson leaned back in her seat, one hand thoughtfully under her chin. "Counsel, some might say your coalition is using legal theory as a vehicle for political grievance." Bondi nodded. "And some might say judicial caution is used as a vehicle for executive excess. But in this chamber, I trust we deal not in cynicism, but in constitutional first principles." Silence. Then, unexpectedly, Justice Thomas broke the stillness. "This court has not seriously confronted the vertical boundaries of federalism in nearly a generation," he said, almost to himself. "Perhaps it is time we did." The statement hung in the air like smoke from a cannon. Justice Barrett, for the first time, shifted her gaze, not to Bondi, but to her colleagues. A silent exchange, unspoken calculation. Pamela Bondi gathered her papers. She had not won, yet. But she had done what few had expected. She had changed the equation. No longer a formality, her argument was now a live wire on the court's docket. Justice Gorsuch asked one final question. "If the court were to rule in your favor, how would that affect the administrative state as we know it?" Bondi didn't miss a beat. "It wouldn't dismantle it, Justice Gorsuch. It would re-anchor it to the Constitution. And that, I believe, is not destruction, but restoration." As the red light signaled the end of her allotted time, Bondi stepped back from the podium. But she hadn't stepped down. She had planted a flag. The justices' deliberation stretched long into the following weeks, longer than court watchers had anticipated. Commentators on both sides of the ideological divide were restless. The press speculated wildly. Was Barrett leaning toward Bondi's framework? Had Thomas swayed the conservative bloc? Could the liberal wing fracture under the weight of constitutional complexity? But inside the marbled corridors of the court, a quieter, graver reckoning was unfolding. Justice Amy Coney Barrett sat alone in her chambers one late evening, surrounded by thick legal tomes and a spread of handwritten notes. Her copy of Harrington v. Davis was dog-eared, filled with fresh marginalia. Beside it, Montgomery v. Louisiana, its footnotes underlined twice. A cup of cold tea sat forgotten. Her mind circled back, again and again, to one phrase Bondi had used during oral arguments. doctrinal honesty. The weight of it unsettled her, because Barrett, unlike many, understood that sometimes the most dangerous arguments were the ones that echoed her own intellectual instincts, refined, methodical, rooted in principle. Bondi hadn't tried to sway the court with passion. She had done something far more dangerous. She made the originalist case better than some of the justices themselves. 2 weeks later, the opinion was released. Bondi v. United States, a 5-4 decision. The court ruled in favor of Bondi's coalition. Chief Justice Roberts authored the majority opinion, but it bore the unmistakable fingerprints of Barrett's internal influence. It was narrow in language, but wide in implication. The decision reaffirmed the need for federal action to satisfy a clarified 3-part test when encroaching upon areas traditionally reserved to the states. While stopping short of overturning Reich, it reinterpreted the scope of the Commerce Clause in light of Harrington, Nick, and even the much-cited Montgomery footnote. Justice Barrett penned a separate concurrence. And it was her words, not Roberts's, that would be quoted in every law school classroom and political arena for the next decade. Federal power, however compelling in motive, must yield to structural boundaries. Ours is not a government of convenience, but of consent. And consent begins with clarity. Justice Sotomayor, writing for the dissent, did not hide her alarm. Today's majority cloaks constitutional fidelity in the garb of federal restraint, but the garment is threadbare. What has truly occurred here is the beginning of a judicial shift whose endpoint we cannot yet see. Outside the court, the political world ignited. 17 governors issued joint statements declaring victory for state sovereignty. On Capitol Hill, the ruling sent ripples through regulatory agencies as attorneys scrambled to reevaluate the scope of federal guidance under the new framework. Pamela Bondi emerged from the courthouse steps into a whirlwind of flashing cameras, microphones thrust toward her face. A reporter shouted, "Miss Bondi, did you expect to win?" She paused, gaze steady, and answered with a slight smile. "Number I expected to be heard. The win, that's for the Constitution." Her voice cut through the noise, steady and firm. And just like that, what had begun as a quiet challenge, dismissed by pundits and doubted by scholars, became a watershed moment in constitutional law. Pam Bondi had walked into the highest court in the land and walked out having changed it.